Can you see the screen now?
Yes, ma'am.
Fine. So we are beginning with the law of thoughts, right? First of all, can anybody, like anybody of you, can tell me like what is thought or what is thoughts? Anyone?
Ma'am, it's a civil wrongful act.
Sorry, I couldn't hear you.
Ma'am, it's a civil wrongful act.
Okay. So one answer that I got was that it is a civil wrongful act. Anybody else? Fine. See, when we begin with law of thoughts, right? First, this term thoughts in itself is a very new word that we hear, right? So we need to understand that what actually thought means. Derived from the Latin word totum. First of all, they're telling you that thoughts is a word that is derived from the Latin language, right? And what is that word? And what is that word from which the word thoughts has been derived from the Latin language? That is thoughts. Sorry, really sorry for this. Yes. And what is that word? Totem, right? And what does that word totem means? To twist, right? In the simplest language, if I put it, then thoughts is something which is crooked in nature, which is wrong in nature. And yes, Mahima was right. It is a civil wrong against an individual, against a group of individuals, and that is what is called as torts. So, if you read the whole definition derived from the Latin term totum, meaning to twist, indicating an unlawful conduct, an act or an omission. I'll explain you why I'm using these two words, act or omission. Right? This is an act or omission which is unlawful in nature. Something which is illegal, which is not approved in the eyes of law. Right? It is an unlawful conduct. Law of torts originates from the common law of England and is well developed in the UK, USA, and other advanced countries. In India, it remains non-codified and under development. What are they telling you? That this torts is not yet developed in India. Neither it has been originated in India. They're saying it has originated from the law of England. That means it is an English law which we have adopted in our country, but yet this is not fully developed. It has been developed in UK, USA, and other advanced countries, but it still remains uncodified and underdeveloped in India. Right? Till now, am I clear to everyone?
Yes, ma'am.
Yes, ma'am.
Fine. To look at the definition of tort given by the different authors, first of all, let's see the definition that is given by Professor Winfield. Right? Tortious liability arises from the breach of duty primarily fixed by law, redressable by action for unliquidated damages. What are they saying? Any tortious liability. That means if somebody has committed any tort, and what will be that person's liability? How will that person be liable? Is defined that that person had a had a duty to be performed by law, and that person has done a breach of that duty. That means that person has not fulfilled that particular duty or violated that duty, right? Supposedly, let's take an example. Just give me a moment. Yeah, let's take an example. A and B are two people, right? A goes to B's house, right? And this is B's house. And A enters B's house without his permission, without his consent. Fine. So tell me, has A violated something, or has A done any offense? Anybody?
Yes, ma'am.
And what is that?
A entered B's property without B's permission.
And what was his duty that he has to like fulfill in law?
He has to
What was
ask the
his?
permission.
Yes, exactly. The person has to take the permission of the other person entering into his or her house, right? So A's duty was to what? Was to take the permission of B before entering his or her house, right? And that is why A has committed trespass into B's house. You will understand what trespass is in the future classes, but we can clearly see that A has committed a wrong. And that is what Professor Winfield is saying, that it was a duty which had to be performed, but the person has breached the duty. And how can it be redressed? That it comes with an action for unliquidated damages. Can anybody tell me what do you mean by unliquidated damages? Or can anybody tell me what is the difference between liquidated and unliquidated damages? Anybody? See, let me just clarify you with the rules of my class. Just two rules, simple rules. One, you can just unmute yourself and speak up. I don't have a problem of you guys speaking. You guys don't have an obligation to write on the chat, right? Just speak up whenever you feel like. Second rule, the only and only condition, the first condition will be applicable only if you're just maintaining the decorum of the class. You're not just unmuting yourself to create any sort of nuisance, right? You can just speak up whenever you feel like. And I want this class to be an interactive one. If I'm asking questions, then just reply. If you don't know it, then that's fine. But just interact with me, right? So that you guys also not sleep and I'll also not sleep, right? So just, yeah, anybody who can just tell me that what is the difference between liquidated and unliquidated damages? No? See, liquidated damages are the ones which are pre-decided damages, or we can say a pre-decided penalty. Like supposedly, if somebody is entering into a contract and they're saying that if you breach this contract, then you will have to pay me a penalty of rupees 50,000, right? Before entering into a contract only, they have decided their penalty, that if any sort of dispute happens, and if any dispute happens, then you will have to pay me a 50,000 penalty. But unliquidated damages are not pre-decided. That means you decide the penalty by looking at the facts and circumstances of the case. Non pre-decisive. Those damages, or you can use the word compensation, which is not pre-decided. You're deciding it as and when that breach of duty is happening. Do you get my point?
Yes,
Yes,
ma'am.
ma'am.
Fine. Moving further to the definition given by Sir John Salmon, a civil wrong with a common law remedy for unliquidated damages, distinct from contract breaches, trust breaches, or equitable obligations. In the same, the definition is almost same, but they are here giving you certain exceptions, that what will not be considered as tort, that contract breaches will not be considered as tort, trust breaches will not be considered as tort, and other equitable obligations. That means they are saying that torts are civil wrongs. That is fine. That he is also accepting. But then, just, yeah, yeah. Tort is a civil wrong, but then you are differentiating a civil wrong from contract breaches, trust breaches, and other equitable obligations. That means he's differentiating tort as another offense apart from contract breaches, because we have specific statutes for that particular breaches that are happening. For the contract breach, we have Indian Contract Act. For trust breaches, we have Indian Trust Act, right? All these things are not treated under law of tort, and that is why they are different, and all other civil wrongs are treated as law of tort. Right? What is section 2 of the Limitation Act saying? Defines tort as a civil wrong, not exclusively a breach of contract or trust. The same definition which Sir John Sarment is giving. Right? Fine. Yes. And one more thing, if you guys are writing anything in chat, I would not I'll not get to know, because I'm teaching you and my focus is not on the chats right now. So yes, so what will happen is that if at any point you feel like if your question is unaddressed, then just raise your hand and then I'll look at the chats if you're not comfortable in speaking. Right? Fine. Now we have to see what are the constituents of tort. What do you mean by constituents? What are the elements or what are the ingredients of torts? What are the ingredients of a tort, right? A wrongful act or omission by the defendant. Who is a defendant? Who is the wrongdoer? Who is committing a civil wrong? Right? And what is a wrongful act or omission? An act, anything which is a civil wrong, like nuisance, you can say, battery or assault, you can say. And what do you mean by omission? Can anybody tell me what is omission? Any example of omission? Anybody? Nobody knows the meaning of omission.
Like when you don't perform a duty that you're supposed to.
Yes, exactly. And what is the example that we can take here? The last example only that we took of trespass. It was his duty to take the permission from the person before entering into his house, and that person omitted to take that duty, and that is why it is an omission and a tort as well. Right? In the tort, how is the legal damage happening? It is happening from the act or from the omission. That was a person supposed to do or not supposed to do, and he has done that, then that would be resulting into the legal damage. And what is the meaning of damage here? The meaning of damage is injury. How is the injury happening to the plaintiff? Who is the plaintiff in our case? If I take the same example, A and B, who is the plaintiff in our case?
B.
B.
B. Because A entered into B's house and A is the defendant. Fine. And what will be the legal remedy? That I clearly told you. Damages, that means compensation, which is undecisive, or you can say unliquidated. Fine. Clear? All the 3 points?
Yes,
Yes,
ma'am.
ma'am.
Purpose of law of tort. Now, to understand why this law of tort has been introduced in the country like India, and what is that one thing that what is the need that we need to study the law of tort, right? First of all, let's understand the concept of equity and justice, right? See, balances rights within society. What are they saying? That equality and justice is something which needs to be served to everyone in the society. And this is what law of tort do, that they are balancing your interest between whom? Between society and one more party. And what is that party? Can anybody tell me? Balancing the rights between whom? It acts as a bridge between society and whom? Tell me. Society and whom? Individual rights. Society is comprised of several individuals, but then you have your rights as well, right? So what law of tort do is that it maintains social welfare as well, and it maintains the individual rights as well. And this is called as the theory of social engineering. That neither the social welfare is getting hampered and neither the individual rights are getting hampered. Doctrine of perfect rights ensures rights have equitable remedies. What does this statement means? That if a law of a country has given you certain rights, let's say constitutional rights only, or you can say your fundamental rights, fine. Then the country is also liable to give you the remedy for those rights if these rights are violated. Supposedly, right to vote is your fundamental right, but then you're not allowed to vote. Is your right violated?
Yes,
Is
ma'am.
your right violated?
Yes, ma'am.
Yes, your right is violated. And if yes, then you also have the right to get a remedy for it, either in the form of damages or either in the form of any sort of compensation. Right? Now, the theory that I had mentioned, social engineering, was given by whom? Was given by Roscoe Pound and William L. Prosser. Right? And what is the theory of social engineering? I'm repeating here again. A theory of social engineering is where both the rights, whoever has unmuted yourself, please maintain the decorum of the class. Don't force me to remove you from the class. Whoever has unmuted themselves, don't create nonsense in the class. If it was by mistake, then I totally understand that. But if you have done it deliberately, don't. Fine. So where was I? That social engineering theory. Social engineering theory given by Roscoe Pound and William L. Prosser says that a social engineering theory will be something that maintains the bridge between the social welfare and the individual rights that needs to be followed, and you cannot deny the social welfare as well, and you cannot deny the individual rights as well. Understood, everyone?
Yes, ma'am.
Yes, ma'am.
Now, there are two theories in the law of torts, right? The first one is the Winfield's unity theory, and the another one is the Salmon's pigeonhole theory, right? And what are these theories for? That is it a law of tort or is it a law of torts? You're gonna tell me that. कि हम law of tort बोलते हैं, we say it law of tort, or we say it law of torts. Guys, just give me a moment. I am receiving a very important call. You guys, till then, just speak your answers. Just give me a moment. Yeah, I'm really sorry for that. Yeah, can anybody tell me, is it law of tort or is it law of torts?
Law of thoughts.
Torts. And why is that? Can you support your answer?
Ma'am, because as it is mentioned in Salmon's pigeonhole theory, there are various thoughts like nuisance, negligence, and so like this.
So did you read it from here or you knew it from before?
Ma'am, I read it from here.
Fine. Smart play. Okay. So what does Winfield's unit theory says? That it is Winfield is being very rigid in its theory. He's saying that it is a general principle for the liability of tort, and he's saying that opens a room for newer injuries and their remedies. That means that means I broke your confidence, Harsh. I said it opposite just to test your confidence. It is never law of
Okay, ma'am.
torts. It is law of tort.
Okay, ma'am, understood.
Understood? Yeah. So what is happening in Winfield's units of theory, that he's saying that if any new injury is happening to another person, then we have a room where we can fit those injuries. There is no restriction. That means if this is a room and if there is a gate, then the new torts can enter into this room via this door, right? I'm talking in a very layman language, but where else? Where else? What is this Salmon's pigeonhole theory saying? Specific torts like nuisance, negligence, strict liability, etc. If a case fits, it constitutes tort liability. What are they saying? That he is becoming very rigid over here, that there is only this room for torts and all the torts fit in this room only. Like if you mention nuisance, if you mention negligence, if you mention strict liability, he's saying that this is the only room for torts and no new tort can enter into this particular tort, right? So you tell me, what do you think, that what is better, a room open with a gate where new injuries can enter, or a room rigid where all the tort liabilities are already there and there is no space for new injuries to enter, and if any new injury does not fit into this particular room, then the person will have no remedy for that injury that has happened to him. Tell me, which is better? Law of
The former one.
tort is better or law for law of torts is better?
Law of tort.
Law of tort or torts?
Tort.
Tort. Why?
Law of tort.
Because in a developing country like India, or we can say a developing world which is developing on everyday basis, so there can be new injuries apart from these injuries that will be gonna studying, like nuisance, negligence, strict liability, absolute liability. There are certain things that are gonna enter into this room, and there has to be always a space for the remedy that needs to be provided for those particular things, and that is why we always say it law of tort. We say it law of torts also. Many of you will say it law of torts also. But the accepted and less criticized theory is law of tort, because there should be always be a room for the injuries to enter. Understood, everyone? Winfield's and Salmon's theory?
Yes, ma'am.
Yes, ma'am.
Fine. Now let's understand the difference between, I gave you certain examples, right? Now let's understand the difference between a tort and a crime, a tort and a contract, and a tort and a breach of trust, right? Can anybody tell me the difference between a tort and a crime first? Anybody? Tort and a crime. Very simple. You have understood the definition of tort. So you must be knowing the definition of crime as well, right? That the difference lies between their definitions only.
Ma'am,
Just
in a crime, yes, the main motive is to punish the person who does the crime, and
yeah.
in torts, we try to this reach a conclusion, and the compensation can also be given apart from just punishment.
Okay,
It
what's your
can be
name?
both. Marushika.
Sorry,
Sorry. What?
what's your name? Like,
No, she.
no, she. You're right, but you forgot the main difference only. Just the main difference which which we can see from
Oh,
the words
civil.
itself.
Tort is civil, and
Exactly,
crime can be
exactly.
civil or criminal.
Yes, the crime in itself is showing you crime in itself is showing you that it is a criminal act. You are doing an offense, right? And whereas what is tort? Tort is a civil wrong, right? So let's see the difference between tort versus crime. Tort, private wrongs, civil cases, compensation by the wrongdoer. Torts may, you never give a punishment to the person. You always provide a remedy, and that is damages. That means the other word that we can use is compensation, right? Whereas in the crime, it is public wrongs. What do you understand by public and private wrongs? Any difference? Public and private wrongs.
Ma'am, public
Private
wrong
wrongs
is
usually affect a private wrong. It usually affects one person, one individual, whereas in crime it affects the act of the crime. It affects a society as a whole.
Very good. Anybody else? Anybody else was speaking? I think Harsh was speaking.
ma'am, public wrong is the crime which affects public at large.
Can you speak a bit clearer? I can't hear you.
Ma'am, public wrong, like it is a wrong which affects the public, and in private
Yes,
wrong it
public
affects the
wrongs are the
individual.
wrongs. Yes, public wrongs are the wrongs that are hampering the public at large, right? Whereas the private wrongs are the wrongs which are particularly against an individual, right? So torts are the private wrongs, crimes are the public wrongs, right? In tort, if any case we are taking it to the court, then it will be a civil case, and the individual to individual case would happen, right? Whereas the state is involved in the criminal cases. Whenever you do your law, and if somebody will go into litigation, like they'll be doing the practice in the courts, they'll see whenever a criminal case is filed, they'll see that the case name is always state versus whosoever, because it is considered that a crime is always done against a state, and that is why the state is made the party, right? And this I have clearly told you that in the case of torts, we do not provide punishment to the wrongdoer, we provide compensation, and in the crimes we provide punishment to the offender, right? Understood?
Yes, ma'am.
Fine. Now let's see the difference between tort versus contract. What is contract? Breach of self-imposed duty, specific individual obligations, liquidated damages. What that means is that the two parties have imposed the duties by themselves. Like nobody asked them to enter into the contract, right? They had what? They had their motive to enter into the particular contract, right? They had their obligations to be fulfilled by themselves, right? If A and B are entering into a contract, it's their duty to perform the contract and to fulfill their obligations. And if they don't, then Just a moment, everyone. There is some internet lagging. Just a moment. Fine. Yeah. So I've changed the line. Yeah. So in the contract, what is the thing? That breach of self-imposed duties, the duties that have been imposed by the persons themselves, right? Specific individual obligations. Both the parties, when we are talking about contract, like if A and B have entered into a contract, both the parties, A and B, have their individual obligations that needs to be fulfilled in that particular contract. Let me give you an example for this. Like if A is selling his car to B for 5 lakh rupees, right? So can anybody tell me like what is the obligation of A and what is the obligation of B? Tell me. A's obligation and B's obligation.
A's
Anybody?
obligation is to sell the car and B's obligation is to pay the 5 lakh rupees for that.
Money. Very right, Harsh. But then can you tell me one more thing? Like if they have the obligation, did anybody else told them to enter into this obligation, or was that a self-imposed duty?
Self-imposed duty. No?
Yes, self-imposed duty. And that is why there in the contract, it is usually a liquidated damages. That means if supposedly A gives the car to B, but B doesn't pay the 5 lakh rupees, then how much A will get the amount?
5 lakh rupees.
5 lakhs. And that is why it is a pre-decided penalty and it is a pre-decided what? Pre-decided damage that needs to be given by B to A. Right? Understood the contract thing clearly?
Yes, ma'am.
Yes, ma'am.
Now, let's see the tort. Breach of law imposed duties, general obligations, unliquidated damages, broader remedies. Simplest example that I took at the initial of the class, A entered into B's house without B's permission, which is called as a trespass, right? Have they obligated themselves for anything? Or the law has obligated them to not enter into each other's house without anybody's permission? Who has done that? Tell me.
Law has obligated me.
Law has done that. Why? Because if you see very clearly, if I am taking this responsibility that it's my duty to know to not enter anybody's house, then this is the duty that has been imposed by law on me. That particular person has not imposed the duty on me, because how would he know that when will I enter his house? He doesn't know that thing that that I'm gonna enter his or her house, right? So that is a law duty that has been imposed on me, that I cannot enter anybody's house without anybody's permission, right? So it is a law imposed duty. And there are general obligations. General obligations meaning that this is general for everybody in the society that they are living in, right? General obligations. What do you mean by general obligations? That everybody needs to fulfill that particular duty. They are general, they are common for everybody, right? Unliquidated damages. Nobody can decide the penalty, that if that breach of duty happens, then how can you pre-decide the damage? Because how would I know that somebody is going to trespass on my property? How can I just like impose a duty? Sorry, how can I just impose a penalty before even knowing that when is that going to duty be breached? Right? So that is why there are always unliquidated damages in the law of tort. Understood the difference between contract and tort?
Yes.
Everybody.
ma'am.
Any doubts? You can just unmute yourself and speak up. Fine. Yes. So now let's see the difference between tort versus breach of trust, right? What are tort? We have seen it. Unliquidated damages, part of common law related to property law, right? What do you mean by trust? Liquidated damages again, part of court of chancery, breach of property law. Okay? Have you ever heard someone saying that this person is the trustee of this particular organization? Anybody? Like if I say I'm the trustee of this particular NGO, or if I can say I'm the trustee of this particular school, what do I mean by that? What do I mean by that? Anybody? You have never heard that who is a trustee?
Yes, ma'am. Ma'am, basically it means that you have access to the assets of that organization or charity or whatever you are the trustee of.
Yes, and who is speaking? Who is giving the answer?
Amya.
Soumya.
Amya.
Amya, okay. See, as we have combined the two batches, so I request everyone that whenever you're speaking, just please introduce yourself and then speak up so that I know who I have to address to. So just do that, right? From the next time. Yes, Amya, you're very, very right. Trustee is someone who is looking at the money or property of somebody else. Like he has a trust in that property and he has a faith in that property and he has an interest in that property, and that is what is called as trust, right? And if a trustee is breaching any duty, then they have a pre-decided penalty that needs to be paid to the other party, and that is what makes the difference between a tort and a breach of trust. Understood?
Yes, ma'am.
Fine. Moving forward to the perfect and imperfect rights. Till now you will be thinking that मैम ये क्या पढ़ा रही है, मैम ने पहले थ्योरी पढ़ाई, मैम ने फिर ये पढ़ाया कि डिफरेंस क्या होता है, अब मैम परफेक्ट इम्परफेक्ट राइट पढ़ा रही है. Everything will make sense. Everything is gonna make sense just after 5-10 minutes, right? I am making you understand these things because these things are something that will set your basics for the law of tort. Getting my point? Because if you'll not understand this, and if I start picking you up directly to the torts that are specifically mentioned, then you'll not be able to understand the things that we're going to study in future, right? So everything is going to make sense. Just wait for 10 minutes, right? Fine. Perfect and imperfect rights. The perfect right has the following features. It is recognized by law. It is enforceable by law. So in case of breach of this right, a person may go to the court for enforcing this right. That means simplest thing, your fundamental rights and your constitutional rights that are guaranteed by the law. That means if such rights are violated or broken by any other individual or a group of individual or any institution, then you can just clearly approach the court and you can get your remedy, whatever fits for it. Right? Getting my point? Perfect rights
Yes.
are something which are recognized by law, and they are not only recognized by law, they are also enforced by law. That means you can approach to the court for enforcing them. Thus, all fundamental rights, with right to equality, right to religion, are the perfect rights as they are enforceable by law. Fine. What are the imperfect rights? The imperfect right has the following features. Yet again, this is also recognized by law, but they are not enforceable by law. This means that a person cannot go to the court for the breach of imperfect right. Can you tell me anything? Any example? What are imperfect rights? Like they are recognized by law, but you cannot go to the court for enforcing them. Any right? which is recognized, but you cannot go to the court? Tell me, it's very, very easy.
Ma'am, are directive principles of state policy included?
Yes, you're right. Somewhere you're right. And see, you're right, directive principles of the state policy. But then, how can you forget time-barred debts? Can anybody tell me what they understand by time-barred debts? The word in itself is telling you the answer. Time-barred debts. What do you mean by debts? हिंदी में बता दो. Debt का क्या मतलब होता है?
Loan.
Loan. ठीक है. उधार. ठीक है. And what do you mean by time-barred?
Fixed
What do
in
you
a
mean?
particular time period.
Sorry? I couldn't hear you.
Fixed in a particular time period.
Fixed in a particular time period, or you can say it this way. Supposedly, A and B. A took a loan from B for rupees 10,000. He took it on, what is the date today? 25th of September. Fine. 2024. B said that you have to return it by anyhow 25th of December 2024. Fine. Now A didn't return it supposedly before 25th of December. Now B has a right to approach the court, but B has a right to approach the court within 3 years of the cause of action that is given under Limitation Act. Sorry. That is given under the Limitation Act, that you can approach for your loan for 3 years only. So supposedly the cause of action, that means the harm happened on which date? 26th of December. Why? Because till 25th he had the deadline, but he didn't give it. As soon as he didn't give it, from 26th the injury happened, because he has still not returned the loan. Are you getting my point, what I'm trying to say?
Yes, ma'am.
Yes. So 26th of December, what will be the 3 years from this now? What will be the date 3 years from this date? December
2027.
2027, right?
7.
But in these 3 years also, this B didn't file a case in the court, and suddenly after this date he remembers, oh, that I have to take my 10,000 from A. He hasn't received given it in the past 3 years. Now I should file a case against him. Can he do so?
No, ma'am.
No. Why? Because this is a time-barred debt. You have lost your right to get back your debt, and you have lost it because you were sleeping on your own rights. The court has given you enough time for the 3 years to do what? To file your case and to get back your debt. But you didn't do that. You slept on your rights, and that is why the court will also not help you. Understood? Everyone? Perfect
Yes,
and
ma'am.
imperfect rights. Fine. Now let's come to rights in rem and rights in personam. Personam word से क्या ध्यान आता है?
A person.
A person. Very good. This is how you can just remember your legal maxims. ठीक है? And rem से तो कुछ याद नहीं आएगा. But
Remedy.
very good. ठीक है? देखो, a right in rem, also known as jus in rem, is an intangible right held by an individual or entity against the entire world. a right that you hold against the entire world. That means nobody in the entire world can claim that particular right from you. Nobody can in the entire world can say that this right that belongs to you belongs to me. Can anybody give me an example of such thing? That a particular right that belongs to you and only you, and nobody else can claim it.
Like a son has a right on his father's property, not anybody else.
Why can't the brother of the particular person ask the share in the property of his father also if there are two brothers?
Yes, ma'am, he can ask, but like out of the family किसी को right नहीं होगा.
Yes, exactly. ठीक है? So what are they saying? A right in rem is a negative right which primarily serves to prevent others from interfering with the holder's enjoyment of that right. That means if you have the right to enjoy that particular right, nobody else can come and interfere in your enjoyment of that particular right. You have the exclusive right to particularly enjoy that right. This type of right is often associated with the property and ownership. Let's take an example. Ownership of a car. If X purchases a car, X holds the right in rem concerning the car. That means no other party can disturb X ownership of the car. If I have a car at my name, or if I say if I have a car, if I have a house at my name, or you can say I have a piece of land at my name, can anybody come and say me that this is not your land, this is the land that I owe? Tell me.
No,
If I
ma'am.
have the ownership, exclusive ownership of that particular land or car or house, whatever the thing is. Can anybody do that?
No, ma'am.
No. And that is why I have the right in rem. I have the remedy against the whole world. Fine. The next one is the right in personam. As you mentioned, the word personam dictates the word person. Right in personam or just in personam. Can anybody tell me the meaning of just in law?
Justice.
Justice.
Justice. Very good. Right. Is a personal right enforceable against a specific individual or group. The right in personam, the phrase in itself is telling you that you hold this particular right that you hold this particular right with one person only. You do not hold this right against the whole world. Right? It arises typically from contractual obligations and is a positive right requiring the obligated party to act or refrain from acting in a particular way. Supposedly, if I owe 25 lakh rupees to someone, okay, and I have to give 25 lakh rupees to supposedly Barkha and Harsh, okay. Barkha owes 25 lakh rupees to Harsh. Okay. Can anybody apart from Harsh come and ask me for 25 lakhs?
No, ma'am.
No, no.
Why? Why? Give me the reason. Don't say yes or no. Explain it.
Ma'am, because it's a consideration between Barkha and Harsh.
Yes, exactly. Because the two parties entered into the contract of giving each other or taking each other like 25 lakh rupees, and no other else party is, no other party is involved in this particular transaction, and that is why Barkha and Harsh are obligated to each other, and no other party can come and ask me to give that particular person 25 lakh rupees. Right? If A sells his house to B for 25 lakhs, A's right to receive the payment from B is a right in personam. He cannot ask B, if A is selling his house to B for 25 lakhs, then A can ask the 25 lakhs from B only, and he cannot ask it from anybody else. And that is what is said in right in persona. Right? Rent agreement. If B rents his farmhouse to C for 5,000 per month, can he ask for the rent from anybody else, whoever is not even staying at his farmhouse? Or can he just ask those 5,000 from C only? Of course, from C himself, right? So that is why these rights are called right in personam, which is what? Which is just enforced against a particular individual. Right? Now tell me, now I have a very interesting question for you all guys. Tell me, what will be the scenario and in the law of tort? Law of tort is a right in rem or law of tort is a right in persona? And I want everybody to answer this. Batao,
Right in RAM.
why? Somebody has written me in the chat that ma'am please explain in Hindi also. See, मैं दोनों languages में समझा रही हूँ, मैं bilingual हो रही हूँ because see, I cannot use proper Hindi, I cannot use proper English because there are both kind of people sitting here, right? So just I have to use both the languages. ठीक है? हाँ जी. Law of tort is a right in rem or a right in persona?
Ma'am, it's a right in rem because it's a civil offense.
It's a civil offense. Is that the correct reason that you're giving?
Ma'am, it's a right
are-
in persona.
It's a right in persona. Okay. Why, Harsh? Reason?
Ma'am, because only a particular person or individual is involved in it.
But look at the definitions that we have just studied about right in rem and right in persona.
Ma'am,
Then
it
I
would
might
be
think
a
that
right in rem because a right in rem also is a right which is held by an individual, and a tort is also a crime which is a tort is committed against an individual.
but the right in rem is to a right which is available from against the whole world. Then how can you mention individual here? Batao. Those who ever have mentioned that it is right in rem, they are right, but their reasons are not right. Right in rem क्यों है? Law of tort is a right in rem because अगर मैं वो ट्रेसपास वाला एग्जांपल फिर से लूं, क्या मुझे एक पर्टिकुलर इंडिविजुअल के अगेंस्ट ही वो राइट अवेलेबल है? क्या मैं सिर्फ एक ही इंसान को अपने घर में बिना परमिशन के लिए आने के लिए रोक सकती हूँ? कैन आई आस्क एनी वन पर्सन ओनली टू नॉट एंटर माय हाउस विदाउट एनीबॉडीज परमिशन, विदाउट माय परमिशन? Or can I just ask anybody in the world to not enter into my house without anybody, without my permission? Tell me.
Anybody in the world.
Yes, and that is why it is right in rem that the right which is available against the whole world, and nobody can enter into my house apart from me and without my permission. That is why the law of tort is always a right in rem. Understood? Fine.
Yes,
Let's
ma'am.
move forward. Now let's see the two fundamental principles, maxims of tort law. Very, very important for you to understand. The two fundamental principles of tort law are the root level maxims in the tort law, the understanding and knowledge of which is extremely important to understand the concept of torts and how a tort becomes actionable. Let's see that. The first one is injuria sine demonum. ठीक है? साइन का मतलब क्या होता है? साइन का मतलब होता है विदाउट. हमेशा याद रखना. इंजूरिया से क्या याद आ रहा है?
Injury.
इंजरी. वेरी गुड. और डैमनम से क्या याद आ रहा है?
Damages.
Damage.
Damages.
Damages.
This maxim literally means legal injury without damages. Thus, cases of injuria sine damnum includes those instances in which a legal right of a person is violated, but as a result of it, he or she doesn't suffer any loss or damage. क्या बोल रहे हैं कि ऐसा कोई चीज जिसकी वजह से आपका फंडामेंटल राइट तो हैम्पर हुआ है, आपका लीगल राइट तो हैम्पर हुआ है, बट आपको कोई एक्चुअल लॉस या इंजरी नहीं हुई है. ठीक है? Cases of injuria sine damnum are actionable torts. Therefore, the person suffering legal injury is entitled for grant of damages, compensation by the court. Can anybody tell me an example of this? कि जहां पर आपको आपका right तो violate हो रहा है, but then you are you are facing not an actual injury or not an actual damage. What can be that case? Just a second, everyone. Just a minute. फाइन. सो ऐसा कोई एग्जाम्पल जिसमें आपका लीगल राइट तो वायलेट हो रहा है, बट आपका कोई एक्चुअल इंजरी नहीं हो रही है. लेट्स सी एन एग्जाम्पल. A is an Indian citizen aged 21. While going to cast his vote in the general elections of his constituency, he was forcefully stopped by B and was not allowed to vote. A अपना वोट डालने गया, ठीक है, बट इलेक्शंस में उसको B ने मना कर दिया वोट डालने से. ठीक है? उसने कहा कि तुम वोट नहीं डाल सकते. लेटर व्हेन द रिजल्ट्स वर डिक्लेयर्ड, द कैंडिडेट whom A wanted to vote won the election. उसने वोट तो नहीं डाला, बट जब रिजल्ट्स आए तो उसको पता चला कि ए जिसको वोट करना चाहता था वही एक्चुअली जीत गया है. ठीक है? तो इन दिस केस टेल मी, डिड ए हैड एनी वायलेशन ऑफ हिज राइट?
Yes, ma'am.
एंड व्हाट वाज दैट?
The right to
Right
vote.
to vote.
Right to vote.
Right to vote. And did he face any injury, actual injury?
No, ma'am.
No,
No,
ma'am.
ma'am.
Why? Because उसका जो जिसको वो सपोर्ट करना चाहता था वो तो जीत गया ना. So that is why it is said that the candidate whom he wanted to actually win, that is why he couldn't face any legal injury, any actual injury, but the injury that he faced was a legal injury. And a part where he didn't face any actual injury, that time also he will be entitled to compensation because he has been because his legal right has been violated. Understood?
Yes.
So this is a classic example of injuria sine damnum, hence saying that it is an actionable tort. Understood? Fine. Let's move to the another topic, which is damnum sine injuria. Can anybody tell me why damnum से क्या याद आ रहा है?
Damages.
Sorry?
Damages.
damages, right? And in the last slide, I clearly told you the meaning of sign. What was that?
Without.
Without. And injuria means injury,
Injury.
right? So what is the meaning of this particular maxim?
Damages without injury.
Yes, where no legal right has been violated, but an actual injury has happened. Just the opposite of what we read in injuria sine damnum. Right? Such cases are not actionable torts. That means you cannot go to the court for what? For enforcing these particular rights. The plaintiff is not entitled to damages despite the fact that the loss has been suffered to them, because the most essential element of the tortious liability is legal injury. If you want your tort to be recognized by law, then there must be a legal injury that must have happened. And in this case, damnum sine injuria, no legal injury is happening, only an actual damage or an actual loss is happening, but still that is not recognized by law, right? Let's see some examples. A is the owner of a bakery shop and B is his employee, right? A enjoys complete monopoly in the market. After some time, B opens his own shop in A's neighborhood. That led to the competition in the market and customers got divided, leading to a huge money loss to A. Tell me one thing. There is one party, A, who owes a bakery shop in the market. Okay? And nobody else in that particular area holds a bakery shop. Fine. Now, B opens a bakery shop in that particular area. So, now the customers who were going to A's shop are now going to B's shop as well. That means if he was getting 100 customers, so now the customers got divided. Now either they are 50-50, either they are 70-25, whatever the scenario is. A, due to which suffered losses. Now he wants to go to the court and say that B has opened a bakery shop in that particular area, which he is not entitled to do so. Is he right in doing so? And will he get a compensation or damage in that particular case? Tell me.
No, ma'am.
No, ma'am.
Why?
Because there is no
Why?
legal injury here. No legal right is
Better
being
answer.
violated.
Better answer. Explain in the facts of the case.
Ma'am,
Does
in
B has a
here,
right to open his own bakery shop?
yes, ma'am, B has a right to
Yes,
open the
ma'am.
bakery shop.
Of course, yes. Why? Because yes, A had the monopoly, but then why can't B open a bakery shop in that particular area? He can also open the bakery shop in that particular area, right? So A has suffered loss. A has been going through the damages, but then B can also open a same bakery shop, and that is why there has been a no legal injury, and this is what is the case of damnum sine injuria. And B can also open the bakery shop, and that is why A is not liable to get any damages or any compensation. Understood, everyone?
Yes, ma'am.
Yes.
See, I have clearly written here in bold, for a tortious liability to arise, there must be injuria, a violation of a legal right vested in the person, while damnum is the harm, loss, or damage that is irrelevant. Till the time there is not a legal injury that is happening, you cannot enforce that right in the court of law. Understood? Fine. Now let's understand what is strict liability doctrine versus a absolute liability
क्या मेरा ये
doctrine.
पढ़ा हुआ है गद्दी?
Right.
ये मैम तो वो
Sorry. Please mute yourself. What is strict liability? Strict liability roots can be tracked back to the landmark case of Rylance versus Fletcher. ठीक है? Rylance versus Fletcher का एक केस हुआ है, ठीक है, which is a very famous case. ठीक है, strict liability का landmark judgment है, ठीक है. क्या केस है वो आगे पढ़े. Let's see. Essentially, strict liability implies that an individual or entity can be held liable for damages even if no negligence or malintent is proven. What are they saying? That strict liability is the cases where individual can also be held liable if in the case there was no negligence on their part. Right? The focus is not on the rightness or wrongness of the action, but the potential harm that could ensue from it. Right? They are saying that it doesn't matter that whether the act that happened from that particular harm was right or wrong, but they are just looking here that what could be the harm that could have happened from that particular act. We'll see what are the essentials of the strict liability. Non-natural use of land. You are not using your land naturally, that an ordinary person would have used, but you are using your land non-naturally. What do you mean by non-naturally? That a reasonable, a prudent man will not do that particular act. Right? That is a non-natural use of land. The defendant must have made a non-natural use of land something extraordinary or unique that increases the danger to others. Let's take an example. Supposedly, A has put a tiger in his house, right, for his safety. Okay? Can he do so?
No, ma'am.
Why?
Because it's a non-natural use of his property. It can cause damage.
It's a non-natural use of his property, and moreover, it is, yeah, it can cause harm to others, right? Pet animal or just to protect themselves, right? That is a non-natural use of land. Escape. The potentially harmful thing or element that the defendant bought or kept on their land must escape from the area of control. Let's take an example, the same example that I took here. Okay. A and B, two people are there. A is living in a locality, right? And this is his house. Here he has kept the tiger, right? And this is a residential locality. Many people are living here, right? So now tell me one thing. Now this tiger escapes in the locality, and this is the house of B. Okay? And B's child of 6 years is playing here. And now A's tiger bite this child, and this child died. Will A be liable? Of course, yes. He will be liable, right?
Yes.
But suppose now A, who has kept a tiger on his land, and this tiger is just at A's home, has not even escaped, and has not caused any harm to anybody's property or anybody's life. Right? Now will A be liable for anything? Tell me. Now will A be liable for anything?
No, ma'am. Until or unless it causes damage to
No.
others.
Yes, unless and until that non-natural thing is escaping from that particular thing, the particular person will not be liable for the non-natural use of land, right? This is what is the essential ingredient of strict liability. that particular thing must escape from what? From the land, right? Where the tiger is escaping and causing a harm, that is a liability. But where the tiger is at his own position, he will not be liable, right? Damage caused by escaped thing. The damage suffered by the plaintiff must have been a direct result of the escaped substance or a thing. That means the damage that happened because of the escape only. Otherwise, if the damage happened because of any other thing, then that particular thing will not be liable. The damage must have happened because of the escape of the non-natural use of land. Understood, everyone?
Yes.
Yes.
Let's see the exceptions to the strict liability, where the non-natural use of land will also not be liable in what cases. And if even if it escapes, act of God. If the escape happens with the act of God, then that particular thing will, that particular person will not be liable for the non-natural use of land. This involves natural disaster or events which are not influenced by human beings. Where human beings are not involved, any act of God has created any such circumstances which have made the particular person not liable for that particular act because it was not in his hands to control that particular act, right? Consent of the plaintiff. If the plaintiff had the plaintiff has granted permission for the use of such dangerous substance, then the defendant might not be held liable. If the defendant has clearly taken the permission from the plaintiff to use that particular thing on the land, and the plaintiff gave his consent to do that, then the defendant will not be liable for the escape or for the non-natural use of land. Right? Everyone.
Yes, ma'am.
Yes, ma'am.
Statutory authority. If the act causing harm is backed by legislation or statutory authority, strict liability will not be applicable. If any act or if non-natural use of land is permitted or is supported by the statutory authorities of the country, then that will also not be the liability of the person who is using the land non-naturally. Right? Let's see some case laws. The first one, the landmark one, Rylance versus Fletcher. This case is the bedrock of strict liability. Bedrock means the landmark judgment of strict liability. Rylance, the defendant, constructed a reservoir that burst and flooded the Fletcher's mine. What happened? That Rylance created a reservoir on his land, and due to which that reservoir broke down, and this water from the reservoir floated to the Fletcher's mine, due to which he had to face a huge loss. The water floated into the Fletcher's mine. Okay? And there was no mistake on the Ryland's part, because this reservoir busted because of what? Because the contractor did not use the good material while constructing this reservoir. I am telling you the actual facts of the case. कि जब ये वो reservoir बना रहे थे, जो contractor को ये reservoir बनाने का contract दिया गया था, उसने अच्छा quality का material use नहीं किया, used bad quality, जिसकी वजह से वो reservoir burst हुआ and जो पानी था वो Fletcher की mine पे चला गया. ठीक है? तो now tell me, will Ryland be liable for this? For this thing that Fletcher की माइन पे पानी चला गया था?
Yes, ma'am.
Will he be liable?
Yes, ma'am.
Yes,
Yes,
ma'am.
ma'am.
Why?
Because
Why?
he used the non-natural use of land and it also caused damage.
Yes, absolutely. आप अपनी जगह पे reservoir नहीं बना सकते. That is an absolute harm that can be caused to another person, and that is why Ryland was held liable to cause damage to others, and this is a case of strict liability. Right? Green versus Chelsea Water Works Company. The defendant's main burst causing water to flood the plaintiff's premises. The same case. Same case. This happened in 1868. This happened in 1894. Exactly the same case. Same fact, same everything. Right? So, understood? Strict liability?
Yes, ma'am.
Just a second. Fine. Moving further. Now let's understand what is absolute liability. As we explore further, we encounter the concept of absolute liability, a principle even more stringent than strict liability, a person which is more stricter than strict liability. Okay? Absolute liability. It is a bigger phenomena than strict liability. The term may seem similar to strict liability. It will feel like that you are studying one and the same thing, but the difference is, yet the subtitles that differentiate them are crucial. In simple terms, absolute liability is the legal principle wherein the defendant is held liable for the damages caused, irrespective of any precautions taken or exceptions. No leeway is provided, making it a stricter form of liability. What are they saying? That even if you took every chance, to prevent the harm, but still the harm happened, you were very, very cautious, you were very, very preventive that no such harm can cause, still the harm happened, and that is what is called as absolute liability, where you will be held liable still on the basis that even if you took the precautions, then also you will be held liable. Getting my point? Let's see the essential conditions. The first one, hazardous substance. The defendant was involved in dealing with a substance or conducting an activity that was inherently hazardous or dangerous. For example, this is a residential colony and opening an industry in the residential colony from where harmful gases is extracted. Do you think that this is a hazardous substance to be done?
Yes, ma'am.
Do you think that? Yes, of course. Right. Escape, another essential ingredient, that the harmful substance must escape from the area. Must escape. Right. Damage. The escape of the hazardous substance must result in some damages. If no damage is caused, absolute liability cannot be applied. Suppose करो escape हो गया, जो hazardous substance है वो escape हो गया, but उसने किसी को कोई भी harm नहीं पहुंचाया. There was no harm caused. Will that person be absolutely liable?
No, ma'am.
No, ma'am.
No.
No.
Let's see some cases. The very, very, very landmark judgment, MC Mehta versus Union of India. You must have heard about this case, the oleum leak case. Right? What happened? The oleum gas leak case. This incident resulted in the imposition of absolute liability on Shriram Foods and Fertilizer Industries for allowing the escape of the hazardous oleum gas. Okay? What happened in this case? There was this industry. Okay? And in this industry, the oleum gas was escaped, and many, like thousands of people were affected in the residency, right? They took all the measures to prevent this harm. They cut the supply of the gas. They did everything. Still, the people got harmed. The people still got injury. Will the Shriram will the Shriram Foods and Fertilizer Industries be liable for the harm caused?
Yes, ma'am.
Yes, of course. Why? Because despite taking every measure, still the gas got leaked, and that is why the
People go.
industry would be liable for the harm caused. Right. The Bhopal gas tragedy 1984. Union Carbide Corporation was held absolutely liable for the disaster. This incident highlighted the doctrine's application to the foreign firms operating in India. There was a firm that was getting operated in India, which had his quarters in some foreign country, right? And this industry, same, like had a very severe gas leak, due to which many people in the residency were affected. Thousands of people died. Will the company be held liable? The Union Carbide Corporation will be held liable?
Yes,
Of
ma'am.
course, yes. And that is what is the case of absolute liability. Despite taking all the measures, if still the harm is caused, then you will be absolutely liable for that act. Right? This was that what I planned for you in the today's class. But now, before ending of the class, we'll solve one passage. Okay? We'll solve the questions and everybody is going to answer the questions. Right? Let's see the passage first. It is related to strict liability. If a person brings on his land, I'm going to read the passage a little fast because I have explained you the concept. Okay? If there is something that we haven't studied, then I'll explain you it a little slow. But rest, I'm going to read the passage fast because we have less time. We have just 15 minutes. So let's read it fast. If a person brings on his land and keeps some dangerous thing and such a thing is likely to cause damage, if it escapes, then the person will be answerable for the damage caused. Right? We have studied this. Essential ingredients are dangerous substances, escape of that substance, and non-natural use of land and premises. The case law is Ryland versus Fletcher, but the exceptions are the act of God. If there is something that has been done by the God, like for example, tsunamis, tornadoes, earthquakes, extraordinary rainfall, okay? Wind, everything is considered as a act of God, and that will not make that person liable strictly. Strict liability would not arise, right? Wrongful act of the third party. If third party is doing some wrong, third party is involving, and that is what caused the damages, then that would also not be the case of strict liability. Right? Plaintiff's on fault. In several instances, the plaintiff may himself be at a fault for the damage he suffers. In such cases, he cannot shift liability on some persons regardless of how much he suffers. Sometimes what happens is you face damages by your own fault, and that is why you cannot shift your liability to anybody else, and that is what makes you suffer. And if even if how much you suffer, the amount of damages, then you cannot make the other person liable, right? So if plaintiff is at fault by himself, then there will not be any strict liability. Fine. And no, I'm going a little too fast, but I have explained this concept abhi. That is why I'm not reading the passage fully, right? Have you understood the passage till now, everybody?
Yes, ma'am.
Yes, ma'am.
Fine.
Yes.
The Supreme Court of India applied a stricter version of the rule of strict liability in the case of MC Mehta versus Union of India. In this case, oleum gas had escaped from the factory and caused a lot of damage to the people and industries nearby. According to the rule of absolute liability, no exceptions of strict liability shall apply in certain cases. Right? No exceptions. अगर strict liability की हमने कोई exceptions पढ़ी हैं, तो absolute liability के case में वो exceptions भी नहीं लगेंगी. The person will be absolutely liable for the act, right? According to the rule of absolute liability, if any person is engaged in inherently dangerous or hazardous activity, and if any harm is caused to any person due to any incident, accident which occurred during carrying out such inherently dangerous and hazardous activity, then the person who is carrying out such activity will be held absolutely liable. The definition of absolute liable that we just saw. Absolute liability ki definition we saw, right? This is what they are explaining in this paragraph. Understood? Let's see the questions. The first question. Sushant is the owner of a wild dingo, one of the most ferocious dog breeds. He stays in a locality where population density is very high. One day, when Sushant was on his way to the factory, the dog escaped the apartment building and bit one of the ladies in the colony in his hand. The lady's hand need to be amputated. Amputated मतलब हाथ को कटवाना पड़ा. Can Sushant take the defense of any of the exceptions? Read the question carefully. Can Sushant take the defense of any of the exceptions? Just answer me. The options are right in front of you. Either let me know on the chat, or either just like speak up. Tell me. What would be the answer?
Option B.
Option B.
Option B. Okay. How many? Then why not D? Some people are answering me D also. D. No, as Sushant should have not bought such a ferocious dog to a crowd locality in the first place. Why not this option? Can anybody who has given the answer as
Option D,
D, can
ma'am.
anybody explain? Huh?
Because option D is more clear and suitable.
अब आपने आंसर चेंज कर दिया. बताओ
Yes.
बी होगा कि डी होगा?
Option D.
Ma'am, it's not option D because there is no such rule that we cannot bring a dog in a crowded locality.
Okay. Explain it a little further. You are on the right path to answer this particular question that I have asked you. बताओ. Ishika, you were right. थोड़ा सा और explain कर दो. Because bringing a dog to your home is not a problem. Him escaping and then causing harm to the person is important. Escape is important, right? So B would be your right answer. आप dog ले आए, ठीक है, but if he is careful, then that will not be causing a problem. But if he is escaping and then is causing a problem, then that is what is the problem, and that will make him strictly liable, right? So in D, why can't he bring the dog? He can bring the dog, but then he has to be very mindful, and he should have been more careful that he must not have escaped. मैंने आपको बताया था ना कि जब तक वो घर में है और किसी को हार्म नहीं पहुंचाया है, then he'll not be liable, right? So your answer would be B. B. Anybody who has given the D answer clearly understood that why B is the right answer?
Yes, ma'am. Understood.
Harsh?
Yes, ma'am.
Fine. Question number 2. Following the facts in the region because of which the main door to the Sushant's house was unhinged after he had left for his factory. When he came back home, he discovered that the dog had escaped the house and injured a lot of people in the locality. Can Sushant claim any of the defenses? Now the options are in front of you.
B.
B.
Any more answers? Should I see the charts?
B.
Jyoti is saying A. Why? Why, Jyoti?
Ma'am, he can't just like lock the door like so easily. मतलब means like उसको अच्छे से बंद करना चाहिए था. Like he should secure him
डोर
in a
तो
better
लॉक्ड ही था.
But
डोर तो लॉक्ड ही था. यहाँ पे क्या लिखा है? ड्यू टू Due to extremely strong wind.
Okay, it's an act of gods. Then the answer will be
B.
B.
B. Yes, answer would be B because it was an act of God. Normal wind होती और कोई act of God नहीं होता, फिर escape हो जाता तो he would have been liable. But extremely strong wind आई जिसकी वजह से gate खुल गया, ठीक है? And that is why he will not be liable. Right? Next question. Arjun is a young trainee at a National Defense Academy, the premises of which is located right next to the village panchayat office. Every morning, Arjun attends firing practice as a part of training under the National Defense Academy, which is in a compound manned by a fence beyond which is the village. One day at such a practice, Arjun fires a shot which misses the target and hits a villager who was passing by beyond the fence. Can Arjun be held liable? Options are in front of you. अर्जुन एक नेशनल डिफेंस एकेडमी में प्रैक्टिस करता था. उसने एक दिन गोली मारी प्रैक्टिस के टाइम पे और आसपास की जो फेंसिंग थी उसमें बहुत सारे विलेजर्स थे और विलेज पीपल रहते थे, जिसकी वजह से वो जो गोली है वो एक विलेजर को शूट हुई. राइट? सो वी नीड टू टेल दैट विल अर्जुन बी हेल्ड लायबल? Answer.
Option B.
Sorry?
Option B.
Option B. Why?
Because he was carrying dangerous substance which escaped and caused harm
Yes,
to villagers.
absolutely right. नेशनल डिफेंस एकेडमी में प्रैक्टिस कर रहे हो तो इसका मतलब ये तो नहीं है ना कि आप केयरफुल नहीं रहोगे, आपको टारगेट को शूट करना है, बट आपको जब पता है विलेजेस आसपास हैं, ठीक है, तो आपको प्रैक्टिस वहां नहीं करनी चाहिए. देयर शुड बी अ पर्टिकुलर एरिया वेयर यू विल प्रैक्टिस, right? So that is why he was doing an inherently dangerous activity resulting in escape which caused the harm. Right? Next question. PQR Construction Private Limited is building a tunnel through a rural area when it encounters some big heaps of stones and rocks. ठीक है, वो एक टनल बना रहे हैं एक रूरल एरिया में जब उनको दिखा कि बहुत ज्यादा स्टोन्स और रॉक्स हैं उस टनल को बनाते हुए बीच में आ रहे हैं. ऑल्दो द एरिया इज रादर क्लोज टू अ हाउसिंग डिस्ट्रिक्ट, बहुत सारे हाउसिंग डिस्ट्रिक्ट है वहां, मतलब बहुत सारे हाउसेज है वहां पर. दे डिसाइडेड टू ब्लास्ट अवे द रॉक्स एंड स्टोन्स. उन्होंने सोचा कि जो बड़े बड़े पत्थर और स्टोन्स आ रहे हैं इनको हम blast कर देते हैं. X, a 9-year-old child playing in a yard a block away, is hit by a piece of flying stone, causing a deep skin tear. Can the PQR Construction Private Limited be held liable? Options are there. Tell me the answer. मतलब उन्होंने जब ब्लास्ट किया तो एक उड़ता हुआ स्टोन बी 9-year-old के बच्चे को जाके लगा, जिसकी वजह से उसको बहुत ज्यादा स्किन टीयर हुआ. तो यू नीड टू टेल मी द आंसर. Will PQR Limited be liable? बताओ. Answers, guys. What happened?
Ma'am, option B.
B. Option B.
Option D. Why? Reason? Why are people saying option D?
Ma'am, option B is correct.
Ma'am, because he blasted the rock which might cause damage to anyone present there.
Yes, option B would be right. Why are people saying D? Yes, the PQR Construction Private Limited should not have been carried out any blasting activity near a housing district. अरे बाबा, हाउसिंग डिस्ट्रिक्ट के पास ब्लास्टिंग एक्टिविटी नहीं करनी चाहिए थी, वो तो बहुत बात की बात है. आपको एक इनहेरेंटली डेंजर एक्टिविटी करनी ही नहीं चाहिए, आसपास अपना बहुत देख समझ के करनी चाहिए, क्योंकि उनको आपको पता है कि वो डेंजरस एक्टिविटी किसी को भी हार्म पहुंचा सकती है. यहाँ पे जो हाउसिंग एक्टिविटी वाला हाउसिंग डिस्ट्रिक्ट वाला जो स्टेज है वो तो बहुत बाद में आता है. राइट, इसीलिए डी वुड नॉट बी द आंसर. इंजरी किसी को भी हो सकती है क्योंकि वो एक्टिविटी इतनी डेंजरस है, राइट, एंड दैट इज व्हाई ऑप्शन बी विल बी योर राइट आंसर. फाइन. Next question. Following the facts of the previous question, question number 4, while, just a second, just read out the question once, give me a moment. Sorry.
क्वेश्चन पूछिए, मैं आपको ही ढूंढ रहा था काफी देर से, बट आप मिल गए थे. अब आप मिले तो कोचिंग ढूंढ लिया. चलो
क्रैश कोर्स का ग्रुप.
हाँ, क्रैश कोर्स का ग्रुप. हाँ है ना, ग्रुप में ये मैंने बना लिया लिंक बना.
हाँ, मैं आपको ऐड कर.
आपकी क्लास 6 बजे खत्म हो जाएगी ना?
अभी 2 मिनट में खत्म.
तो मैं आपकी यहीं पे लेना क्लास है ना, तो 6 बजे तक जाएगा.
Yes, following the facts of the previous question, while the heap of the stones is being blasted, a small rocky hill situated above the case is in, causing the entire housing district situated in a lowland to be buried under the debris. Several people are reported to be either injured or dead. What is the nature of liability? PQR Construction Private Limited Company.
Option D.
Tell me. Option?
Option D.
I couldn't hear you, Harsh. Option?
Option D. Absolutely liable.
D. Why? Why? Because while the heap of stones and rock is being blasted, a small rocky hill situated above cases causing the entire house district, पूरी की पूरी वो house district बैठ गई, debris, like it got just buried. ठीक है, तो चाहे आपने कितना भी prevention किया हो, you are strict, absolutely liable for what you did. Right? Understood, everyone?
Yes, ma'am. Yes, ma'am.
So this was your class for today. I hope you enjoyed the class. I hope that I was able to convey you that what was we are going to start with, the thoughts and everything. And yes, is there any questions or anything that I can just explain you with? Any doubts, anything? Did you enjoy the class, everyone? Did you like the class?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Fine. So just a request to you all, as this was your first class in the crash course and some of you had just first class with me, so can you please just drop your feedbacks on the crash course group? It would be really helpful for me because in the very first class we have to take the feedback. So can you just drop your feedbacks there? Just a simple request. Just after class, it will take just 2 minutes. Please drop your feedbacks there. And yes, I'll see you tomorrow. Right?
Thank you, ma'am.
Ma'am,
Thank
thank
you,
you.
everybody. I'll see you tomorrow. Bye-bye.
Bye, ma'am.